You'll be appearing on behalf. How many times this parties have changed counsel?
Because I like to see that some provident funds should go to the employees. Therefore, I want to help or negotiate something with that. Because that lease has been expired. Mining lease expired and suspended from 2020, on 23rd March 2020. So there is no non-functional equivalency from that time here. Therefore, I need little instruction. In fact, I talked to Kostopal also. He said that he had already advanced the argument. They said, all that the fake and they have requested me. And
so 1 week?
1 week, I think. Huh? 2 weeks, I think, is right, because people are coming with their documents. In fact, if I meet Daryl Thaba, then I can do it. I'm trying to contact him.
Mr. SP Manta, Senior Counsel. Have you filed a power?
Yes, power.
Has submitted at the bar that he has been engaged as counsel for this party, for the petitioner, only recently, and as such requires some time to prepare the matter for hearing.
And in fact, item number 5, I'm also appearing there. There is also Kelensi. There's challenged the suspension order, but lease has expired, so that becomes infructuous.
I'll
let it come, then I'll mention.
Lord, item number 2 and 9 is relating to the same
Provident fund. That relating
same issue.
5 is different. 5 is regarding suspension
No,
of
5 is different with regard to suspension of mining lease, but that becomes infructuous.
You're also the new counsel in this item 5?
Yes, actually.
So 2, 5 and 9.
2, 5 and 9. So 5 become infructuous. I've gone through the paper.
Okay, so you're not pressing?
Not pressing. Infructuous because the lease has expired. I want to give that.
So then I'll pass as the orders as far as
because as per this leases expired, you also want 24/5/2023.
Okay, let the matter be called.
As you also.
On preemit, the CMS allowed this matter to 2 weeks.
Obliged.
That will be item 2 and 9.
2 and 9.
Diploma.
Your Lordship, I beg to mention item number 3, Your Lordship. It's criminal appeal, Your Lordship. Pray for 2 weeks' time, Your Lordship. Pray for 2 weeks' time, Your Lordship.
Why? Every time you are asking for time.
Yes, Your Lordship. I need to refresh the court, Your Lordship. You have already submitted the written argument. Everything is done, Your Lordship, except for to refresh the court, Your Lordship.
This will be the last,
Your Lordship.
please. On preemit by the appellant seeking adjournment on grounds of personal difficulty of the learned conducting counsel. That is adjourned. However, it is made clear that no further adjournment will be allowed in this case. This is matter up to 3 weeks.
Your Lordship. Similar for item number 7, Your Lordship.
Nothing.
Let this matter become after 2 weeks, Your Lordship.
What is this matter about?
This is, they have challenged the selection process after having taken part in the process, Your Lordship.
On pre-meet by the petitioner. This is matter of the 2 weeks.
And your judgment.
From daily list, item number 1.
Wait, please, my lord. My lord, the matter can be taken after some time, my lord. The conducting counsel is on legs.
Oh, but you have done your part.
Yes, yes.
Then what is there?
My lord.
Can we take an end of the vote, my lord? It will take some time. Other matters after.
My lord.
End of the vote.
Item number 4.
Please, Your Lordship.
Yes, Mr. Howell.
Your Lordship, this matter, as per the last order, Your Lordship, the new managing committee, they were supposed to file their power.
Oh, yes.
The counsel for the managing committee. And secondly, Your Lordship, like what I have submitted on the last occasion, that the petitioner shall write a letter for compromising of the matter with the managing committee. So the petitioner had written a letter to the managing committee addressed to the secretary. Unfortunately, Your Lordship, the secretary of the new managing committee has also refused to accept the letter, Your Lordship. That is my latest instructions as on yesterday. So I pray, Your Lordship, that on the next date, Your Lordship, the matter may be heard on merits.
Yes. And who is appearing for the managing committee?
I'm appearing for the petition for the managing committee, Your Lordship. We have not received the power yet. We have given for sign, but they haven't returned it back, Your Lordship.
But they have verbally instructed you to appear.
Yes, Your Lordship. They have taken the vakalatnama. They yet to return.
That will be a formality then. I believe within the next date fix you can file your power.
Here the matter on merits, Your Lordship.
Matter will be heard on merits.
Yes, Your Lordship.
I missed Learned Counsel appearing. Learned Counsel has submitted that she has been verbally instructed by the respondent number 5 / new managing committee to appear before this court. However, the power could not be filed today, and aside some time is prayed for the same to be filed. Mr. P. Nongri, Learned Counsel for the petitioner, in the meantime has submitted that though efforts have been made by the petitioner to try and settle the matter amicably outside court, no positive response has been received from the concerned authority, particularly the managing committee. This being the case, it is prayed that this matter may be heard on merit. On pre-meet, same as allowed. This is matter of the 3 weeks.
Public.
Item number 5.
If Lordship permits me, can I just give this?
You have not filed your power.
Power I have filed already.
Oh, you have filed.
In fact, this mining lease is of 23/8/2018, Your Lordship, the first page.
Yes. It's
When
for
it's
a period of
23/8/2018, and next page, if your lordship is pleased to turn, clause 16. The next review and mining plan for the subsequent remaining period of the lease up to 24/5/2023 shall become due on 2/10/2022. However, this petition has been filed, this petition with regard to the suspension of the mining lease, suspension order dated 23/3/2020. That is at page 79, your lordship. So it is non-functional from 23/3/2020, and the lease expired on 24/5/2023. So it was suspended and the company is non-functional throughout this. Then after COVID came, your lordship, then it's non-functional. So my response submission, this become infructuous now.
What is your prayer in this petition?
My prayer in the writ petition, page 18, your lordship. Lordship got that. C. Issue rule calling upon the respondent to show cause as to why a writ in the nature of mandamus directing a respondent to withdraw, recall, and or otherwise forbear from giving effect to an impugned suspension order dated 23/3/2020. There's the prayer. Said that. Since suspension we didn't get stayed there at the time, so it is non-functional, and the lease expired on 24/5/2023.
Who's painful here, say?
Well, look, I appear for the series 146. There is a notification is used by the ministry.
Control of mind. Any
They're placing something dated 23/8/2018, Melon. Well, if they want to withdraw, I have no objection. They can simply withdraw the petition.
Because become
But any kind of
infructuous.
observation that is become infructuous or not, Melon.
No, it is become infructuous. That's my instruction.
and yes, any retrospective recomposition,
Because I do not know, Melon, then I'll require instruction. If they simply want to withdraw it, Melon, I cannot object to that.
No, become infructuous, Your Honor. That is my submission.
if you say become infructuous, then this notification or this communication has to be taken
Yes.
on record.
And this is on 18, Melon, and the writ petition was filed in 21. Were they not aware about this, Melon? I don't know.
No, this you see 18, no doubt. But look at see the
Clause
relevant,
16.
relevant yes clause.
Up to 24/5/2023.
You see, as on the date when this petition was filed,
It was
it
subsisting.
was yes
Suspension.
Yes, it was the company was under suspension, and the lease was under
In
suspension.
subsistence. Under suspension.
And the life of the lease
Expired on
would have
24/5/2023.
expired on 24.
I'll take instruction, Melon, if they want to make it infructuous, Melon. So if they simply want to withdraw, I have no problem.
No, we don't know. It become infructuous because that's the reason.
So what is the difference? I don't know. Because here what happened, Melon? Melon, a lease was given, this is a company, Melon. They're exporting limestone to Bangladesh, Melon. So for certain area of land, lease was given, Melon. Now later on, the Bureau of Mine, whom I'm representing, Melon, they found out that out of the same land, state government has leased out some portion of land to third party. And they are also carrying out mining in the same land. So when the Bureau of Mine people inspected the place, they found that this is absolutely illegal. The mining lease, what has been approved by Bureau of Mine is only for Komora limestone. How can a state government lease out the same land, a portion of same land, to third party who are also carrying out the mining?
No, to that effect, from our side, we have intimated state government, and they issued a lease for the minor minerals for the 5 leases, within the 240 hectares. But our surface area is only 30 hectares. And my colleagues saying 240, the lease area is 240, but mining area is only 30 hectares.
Oh, if that is the case, then the proper parties have to be implicated here. But anyway, that's beside the point.
Yes. But no lease.
As Dr. Muzika has submitted, if you wish to withdraw it, then
No, not withdrawal. It becomes infructuous. The law says infructuous, not subsisting the lease.
Well, I'll have instruction, my lord. If they can bring this by an affidavit, my lord. Or they can file an application, my lord, annexing this, that this is becoming future. So I can have instruction there.
Yes,
It is
Mr.
there, page 67, annexure 6, it is there in the writ petition itself. Page 67, if your lordship is pleased to see.
'67.
67.
Oh, this is the area. You're referring to this map.
No. There's the area it says, your lordship,
Yes.
the 240 hectares,
Oh,
but the mining area is only 30 hectares.
that is not the point.
So
We're looking at the impact of this communication.
that I can bring through affidavit also, there's no issue. If need be, I can do
You
that.
can file an application, my lord.
Yes.
You can file a
You
miscase
bring
saying
it,
that
yeah,
it is
bring
becoming
it back to it, and then you get instructions.
Once they give a copy, my lord, I'll have instruction.
I'll do that.
Mr. S.P. Mahanta, Learned Senior Counsel, appearing for the petitioner, would submit that this matter has become infructuous in view of the communication dated 23 number. Can you number? Oh yeah, Tata. In view of communication dated 23/8/2018. However, the Learned Senior Counsel has submitted that the petitioner may be allowed to bring the said notification on record by way of an affidavit.
I'll do that.
Dr. N. Musical Learned DSGI has submitted that he may be allowed to seek instruction and response to the same, if so instructed, if so advised. Accordingly, on preamble, the same is allowed. Let the said affidavit be filed within the next date fix, with advance copy to the respondents herein, who shall respond to the same if so advised. This is not after 3 weeks.
Deeply obliged.
I know only.
Item number 6.
Yes, Mr. Sama, you're supposed to get instruction.
I got instruction, Your Lordship, and according to the instruction, she is the Nokma, and also Nokma, as you know, Your Lordship, it is on behalf of the clan. But in addition to that, this plot of land, for this plot of land, she has got a separate pata also, Your Lordship. And the reason we can see, I can see from the affidavit of the respondent also in page 9, he said that all the procedure of New Land Acquisition Act has been followed. Yes, sir. And process of linking has been followed, and also compensation amount as per the new rate has been deposited with the Deputy Commissioner. And now the point why it was not released by them, one lawyer for Piloni and Mara wrote to DC not to release the compensation because they are challenging and filing a case in this Honorable High Court, Your Lordship. And for that,
So this issue is connected to another matter.
No, that is regarding Nokma ship, Your Lordship. That is Nokma ship. But that matter has been settled both by the trial court and also the appellate authority of the district council. So they are challenging that one. That is in another bench, Your Lordship. So that is still pending because adjournment from 2018. So this is a matter, sir. Otherwise, there is no connection between that and this one, Your Lordship. There is no stay in that writ petition till then. So this is simply asking for releasing of this. And they said in that affidavit that they are ready to pay to the rear owner. The question, who is the rear owner? That has been settled by the district council court, Your Lordship. Nagme is the rear owner.
So, you would like to argue the matter on merits?
Yes.
You'll argue the matter on merits, no?
Yes, Your Lordship.
So you can start. State out the facts and what is your ground?
Yeah.
But before he begins,
yes,
my senior begins, my lord, only one thing which is not available, my lord, in any of the record is, my lord, no patta is.
I can furnish that one. I can furnish, Your Lordship.
It's not a part of the record.
If it is not
Or
part of,
I can be
if it is
allowed
not part
to
of the
file.
pleadings, how can you do it now?
Yeah, it is not a part of the pleading.
If they are not relying on that, then what is it to you? If the petitioner is relying on certain documents which have not been annexed with the petition or not, or not part of, not found in any averments, then petitioner can make a proper application or prayer. But you're not relying on that.
We are not relying on that, but the record speak that she has also separate patta for that land.
Oh, that's a different issue.
Yes.
So this is basically a demand for land compensation.
Yes, Your Lordship.
Which has been
deposited with the deputy commissioner.
But whose land is now, in dispute? Rather, the title and ownership is in dispute.
In fact, Your Lordship, there is no dispute with the Nogma-ship even.
Okay.
Because the district council has decided both the
That is
trial
your
court
stand.
and this thing. Concurrently, they have the finding. And I don't find any illegality in that finding, Your Lordship. And they have enclosed that finding of the EM and CM in their affidavit in opposition. If we can find page 71 of their...
You start from the beginning, Mr. Sama.
Yes, Your Lordship. Your Lordship, the BSF has taken a plot of land of 22 bika, 4 kata and 12 lisa of the petitioner land right from 2005. And they have approached to the petitioner for land acquisition. But instead of filing for land acquisition, the deputy commissioner asked the petitioner to give
Why would they approach the petitioner?
They approached the commissioner, approached the petitioner to file a no objection or consent certificate. It can be seen from the this one, Annexure 1, Your Lordship, willingness certificate.
Was the proper procedure followed? Section 4, Section 6, Section 9, 11?
Later on, it was followed, Your Lordship. This is the beginning. This is the beginning. They have asked the petitioner to give a willingness certificate. Annexure 1 of the petition, Your Lordship.
Yes, please continue.
Yes. In that one, the petitioner has said, I also declare that I will never make any claim that part of the land in future. I also agree that the cost of the land will be provided by the state government at the government rate. And since then, the petitioner was kept in the dark. So she has sought an RTI from the BSF. What is the position? So they have replied through an RTI, this annexure 2, Your Lordship.
Yes.
And in this RTI, we can see, Your Lordship, that the land they have been occupying is from 26 February 1980, temporary. And that from whom this position was taken, from settlement of this Garo Hill District Council, settlement officer. They said that they have got the copy of the NOCMA document. That means this is the one, and the name of the NOCMA also was mentioned here. Yes, photocopy of willingness certificate received from the owner of the land, Srimoti Nakme Di Sangma, NOCMA Mago Para Akung, West Garo Hill, is enclosed. Then since it was kept in the dark, she has submitted a representation to Deputy Commissioner on 12/9/2013. And again on 17/7/2016, another letter was sent to them. And 25/8/2018, the third letter was sent to them. And 27/1/2020, the fourth letter was issued to them. Then in the meantime, one lawyer from Piloni Mara sent a letter to the Deputy Commissioner not to disperse the amount deposited by the BSF, telling that a matter has been agitated before this Honorable High Court right from 2018.
Where is that letter?
No, agitated means read appeal in another bench.
No, where is that letter that was sent?
We can see that one only from the from this their affidavit in opposition, Your Lordship.
So that letter, no copy was given to you?
No copy was given to me. Only through them only. So we have sent a pleader notice to them for not dispersing the amount. So hence this petition before this Honorable Court, Your Lordship, specifically praying for release of that compensation amount. But in the meantime, the respondent has relied again on that another writ petition which is under bench of this Honorable High Court, WPC 3E3 2018, that it is still pending because they have challenged that order of the EM and CM of District Council. Otherwise, the EM and CM of District Council has already given order in favor of the petitioner. They have declared that she is the real Nokma right from 1927. And this Piloni Mara, according to them, brought through fabrication and by making document, and so they have set aside all those things.
See, Mr. Sangwan,
Yeah.
The proceedings, land acquisition proceedings would be under the old act. It's a 2004 matter, isn't it?
Land
When was the land acquired?
Proceeding was left.
When was the land taken possession by the? Is it 1980?
Not as per the letter, it is handing over of possession of land is 26th February 1981.
1980.
Then
But because of the dispute between them, the land acquisition process under the new act lapsed. They could not
new or
proceed.
old? I don't understand.
Yes.
Because see, if the land was taken possession of in 1980, the acquisition proceedings should have started at that point of time.
It was started.
Even if it has not started, then if eventually they started the formal procedure, then that procedure would have followed, as I have made a query earlier, whether due procedure was followed, taking into account all the relevant provision of the Land Acquisition Act, the old act, or it would definitely be the old act.
Yes,
So where is the compliance of Section 4?
Section 4, Section 11.
Where is it? Is it there?
Those documents are not supplied to us, Your Lordship.
Because first,
but according to them,
see,
they have
first,
gone under Section 40, Your Lordship.
Whatever the case may be, first it goes to Section 4. I'll not.
Yes.
You know better what is the procedure we followed.
Yes.
But if the award is not handed over to you or anyone claiming ownership of the land, there definitely must have been some dispute as far as ownership is concerned, title and ownership, for which the collector has to refer the matter under Section 30. Has that been done?
That was not
now
done.
You say that according to you, if I can understand you properly, you say that the land the compensation was awarded, but not yet handed over to you.
Yes.
Since you are the rightful claimant or rightful owner.
Yes.
Why it was not handed over to you?
Because of the dispute.
Because of the dispute. And that dispute would be in the nature of, you see, a dispute under Section 30.
30. But dispute about Nokmasi Bureauship, I've stated that it was decided by the district council.
Where is the impugn notification or letter or? Where you have made, according to you time and again you have petitioned the collector to release the amount.
Yes, Your Lordship.
It was not done so. So where is the letter?
Letter can be seen from the petition.
There is no impugned letter.
Then there should be a letter issued to you that you have not this.
They
this
have not
amount is
issued letter to us.
Then
only by way of affidavit.
No, Mr.
Affidavit
Sawan,
and
see, this,
opposition.
I
they have.
think your petition is misplaced.
Yes.
What you should have done is,
Yeah.
if you feel that the award that must have been awarded in your name has not been handed over to you or given to you, it would be fit and proper for you to first petition the collector. The collector would say, yes, we'll give it to you, or yes, we'll not give it to you. We will not give it to you because of such and such reason. But if that, you see, if that letter is not on record,
the letter was not issued
then how
to me, you Lordship, but from their affidavit in opposition.
Where is your ground for coming before this court? You are aggrieved by what?
Aggrieved only because of the non-payment only, your Lordship.
Non-payment, is this a forum for you to approach for non-payment? Have you, again and again, I'm repeating the same thing.
Yes.
Have you approached the collector as far as non-payment is concerned? Has any response been received from the collector? Only on receipt of response, then you can take further steps. But that has not been done. Where is your last letter?
My last letter, 2021. 2021.
Is this Annexure 7?
220 is Annexure 6, your Lordship.
Annexure 6. Yes, non-payment. So this is your letter. So where is the response to this letter?
No response, your Lordship.
If there is no response, you should have filed a reminder. If there is no response to that, then
we have sent 4 letters, your Lordship, but they have failed to respond to my letter.
Yes, Mr. Sarji. In spite of receiving 4 letters, why have you not responded?
Of course, my lord, but that we have replied in our affidavit in opposition, my lord.
Only in
So we have
affidavit.
stated the reasons, my lord, that there is a dispute. My lord, my lord may kindly appreciate, my lord, just on the basis of a representation, whether a land acquisition matter can be settled.
We are not on that.
My lord.
See, the first and foremost thing that is to be determined here is this. The petitioner, under the impression that she is the owner of the land taken possession of, for which she is entitled to compensation, has approached the collector or the deputy commissioner. Yes, collector. It is incumbent upon you to reply whether she is the rightful owner or whether she is not. What are the circumstances? You have not done.
My lord.
If you have not done so, that means we can infer that she is entitled to whatever has been awarded.
My lord, my respect
Of course,
to the mission.
that is of course the other aspect of the matter has to be looked
My
at.
lord, the determination of title will be necessary, my lord.
Then why have you not spelled it out?
My lord, in our affidavit, my lord,
And where are the records of the land acquisition proceedings?
my lord, the records were not called, my lord. But however, we have annexed a number of things in the annexures, my lord.
Yes.
So, my lord, what I can, because my lord, today I was under the impression, my lord, that my senior will be, my lord, only on the basis of the instructions. So, if this matter is taken up on any other date, I'll come prepared, my lord.
So, it's 2021 matter.
My lord, it can come next week also, my lord. I have no issues.
If you say that all the necessary details and facts are available here in your affidavit, then so be it. But if records are to be produced, then you have to produce the record.
Yeah.
My lord will kindly see, my lord,
From their affidavit in
annexure
opposition.
2 is there, my lord.
Yes.
Acquisition of land for establishment of BOP at Chandoboi village. So I'm to enclose here with the LA papers in connection. This is at page 15, my lord. So, my lord, I'll require to go through it thoroughly, my lord, if it is taken up any other day.
Yeah.
So, Mr. Sama, as far as you're concerned, your submission is done.
Yeah.
Lordship obviously, in fact, Mr. Sama has section 4 notifications were there also, as per the records. The records should be required. The
Yes,
proceeding has been taken.
that is why. See, if
It cannot be like that, they will just deposit their money.
exactly, that's why the query of
The
the
whole collector record is very important. Though they have given some part in the affidavit of opposition. So, of course, I have not gone through. Just now I check it, I'm sure. So
Lord, I also have to go through it in detail, my lord.
that is why earlier
My lord, prior to, my lord, my respectful submission, my lord, prior to calling of the record, my lord, may kindly allow me to go through his, this affidavit thoroughly, my lord.
if
required, my lord.
exactly, that's what
My lord.
that's why earlier I had made a query
My lord.
as to whether in your affidavit you have stated all the details and the facts with regard to the acquisition proceedings.
My lord. So, the
So-
facts are there, my lord.
So if it is so, then records would not be required.
My lord.
It would just be a duplication. But if not, then the court has to produce the record and see how you have proceeded
My lord.
till the till the extent of award of the compensation.
My lord, it is we are admitting the fact that the award is with us. My lord, only difficulty we are not releasing the money. Our stand is that, my lord, that there is a dispute.
Exactly. So if that is the case, then reference has to be made to court.
My lord. So I will also find out all other necessary
I
things.
think records should be required, Your Lordship. It is the
My
proceeding
lord,
has
at
been
least
taken
let me
place.
go through it once, my lord, thoroughly, and thereafter, my
You go
lord,
through it
we
and
are
we'll
ready
see.
to produce it, my lord, not an issue.
Heard Mr. L. M. Sama, Learned Counsel, appearing for the petitioner. Mr. T.P. Bachari, Learned GA, appearing for the state respondent, has sought for some time to reply. Accordingly, matter is kept part heard the same hearing to resume on the next date fix. This is matter after 1 week.
My lord.
Highly obliged, Your Lordship.
1 week.
Yes.
Item number 8.
Yes. Yes, sir.
This matter can be adjourned today, ma'am. We'll do the argue the other matter, ma'am. More or less common parties, ma'am.
Mr. Sen?
I request you some time.
Could have it next week. Tomorrow? So only a very small issue, Manoj. I think the main hurdle was maintainability, which lordships have decided. The actual dispute is very limited.
As on Order 7 Rule 11.
No, this is a different. This is with regard to the injunction.
Oh, injunction.
You could have it next week if it's convenient.
2 weeks, my lord. As it is pending for quite some time.
On premier by the respondent. Point number 1. The same not be objected to by petitioner. This is matter up to 2 weeks. So 2 weeks.
Obliged.
Second call, item number 1.
October 28. You are in 21 or 28?
21.
21. You're for the Sports Council?
Sports Council.
Please.
But I'll refer to my petition, my lord.
Yes.
From page 4 onwards, my lord. I'll just take your lordship to few paragraphs. Page 4, my lord.
Para 4 or page 4?
Page 4, my lord. Subpara A from the top, my lord.
Okay. Yes.
I'll just read few paragraphs, my lord. That the respondent number 1, Srimati Devris Marbaniyang, proprietor of Messrs. Funny Sports, having its office and so, was an approved government supplier of sports goods. The said respondent number 1 was supplying sports goods to the state government, Department of Sports and Youth Affairs. Lordship's got para email.
Yes.
On regular basis. As on June 2000, the accumulated outstanding amount piled up to rupees 2 crore 66 lakh rupees 28,000. She was supplying goods to the state sports department, my lord. My lord, we are representing a state sports council, which is an autonomous body, my lord. Now, as on 2000, my lord, the total outstanding she was due to get from government was 2 crore 66 lakh rupees, my lord. Then she filed a writ petition, my lord, that the respondent number 1 then approached the Honorable Guwahati High Court by way of WPC number so-and-so, praying for a direction to the state respondents in the said writ petition to release the pending bills of the respondent number 1 amounting to rupees so-and-so, 2 crore 66 lakh rupees. The state respondents during the pendency of the writ petition admitted the liability to the extent of rupees 1 crore 15 lakh so-and-so. As such, the Honorable Guwahati High Court was pleased to dispose of the said writ petition by order dated 30/1/2004 with the following direction. The learned counsel for the respondents disputed the claim of the petitioner and stated that as against the claim of rupees 2 crore 66 lakh so-and-so, the petitioner is entitled to only rupees 1 crore 15 lakh so-and-so. I dispose of this writ petition with a direction to the respondents to examine the claims made by the petitioner and pay her the admissible amount. Necessary payment shall be made within a period of 4 months from the date of receipt of a certified copy of this order. So that was the order, my lord. We have annexed.
Next 2.
Annexure 2, my lord. That is at page 32, my lord.
Anyway, this is the essence of the order.
This is the essence of the order, my lord. So, the government disputed the amount, they admitted only to the extent of 1 crore 15 lakh rupees, my lord. But this Honorable Court, Justice B.K. Sharma's order, my lord, at page 34, that you decide the amount, whatever is the amount, because court did not want to go into the disputed facts, my lord. Thereafter, my lord, para C, my lord.
Yes.
After the said judgment and order was passed, the state respondents made payment of rupees 50 lakh rupees to the respondent number 1. Thereafter, the respondent number 1 again approached the Honorable Guwahati High Court by way of WPC 407, praying for a direction to the state respondents in the said writ petition to release the pending bills of rupees 2 crore 19 lakh rupees. The Honorable Court then by judgment and order dated 18/11/2009 held that out of the amount of rupees 1 crore 15 lakh directed to be paid by the earlier order, only an amount of rupees 50 lakh has been paid. As such, the state respondents are liable to pay the balance amount of rupees 65 lakh rupees. So and so. As far as the remaining amount of rupees 1 crore 50 lakh 73,101 being the disputed question of fact, the respondent number could seek redress from a competent court of civil jurisdiction. It is pertinent to notice herein that the first writ petition, the prayer was for a sum of rupees 2 crore 66 lakh, so and so, out of which the Honorable Court directed for payment of 1 crore 15 lakh, and the remaining amount of rupees 1 crore 15 lakh was held to be disputed amount. Out of the amount of 1 crore 15 lakh, 50 lakh something was already paid, and the outstanding amount was only rupees, is a mistake, my lord, it should be the outstanding amount was 65 lakh rupees, my lord. And rupees so and so disputed. However, in the second writ petition, the respondent number 1 staked claim of rupees 2 crore 19 lakh so and so. The Honorable Court negated the claim of the respondent number 1 and held that the respondent number 1 be paid the undisputed amount of rupees, and as regards the remaining amount of so and so, the same being disputed question of fact, the respondent number could seek redress from a competent civil court of jurisdiction. Thereafter, the respondent number 1 instituted a money suit registered as money suit number so and so in the court of Assistant to Deputy Commissioner. Now, my lord, very crucial aspect, my lord. Lordship has seen that what this Honorable Court in writ petition said, my lord. Her total claim was 2 crore 19 lakh rupees, my lord. Out of that, 50 lakh already paid. Admitted amount was 1 crore 15 lakh rupees. That means court directed to you pay the balance admitted amount, that was about 65 lakh rupees, my lord. So the outstanding disputed claim was only rupees 1 crore 15 lakh rupees, my lord. They file a suit for recovery of, my lord, kindly see, a decree for a sum of rupees 8 crore 88 lakh rupees, my lord. And then interest at the rate of 12%, my lord. My lord, I have said again, it may be stated here in the next page, my lord. After Annex 4, yes. It may be stated here that this Honorable Court by judgment and order dated so and so, Pastor was pleased to grant liberty to the petitioner to seek redress in respect of the disputed amount of rupees 1 crore before the civil court. However, the respondent number filed suit for decree for a sum of rupees 8 crore 88 lakh rupees, stating that the amount includes actual dues including accrued interest till 31/12/2009. The prayer was apparently illegal inasmuch as a principal decree can only be sought for the principal amount, and thereafter another decree can be sought for interest on principal amount. Section 34 of the CPC allows grant of interest on the principal amount but does not allow interest on interest. Further, this was also against the direction of this Honorable Court, which stated that the remaining amount of rupees 1 crore 50 lakh so and so, the same being disputed question of fact, the respondent number could seek redress from a competent civil court of jurisdiction. So, my lord, the first illegality that was committed by them, my lord, against the claim of which they stated before this Honorable Court in a writ petition their outstanding is 1 crore 15 lakh rupees only, they go and file a civil suit for 8 crore 88 lakh rupees, my lord. My lord, next para I'll read, my lord. Yes. Aforesaid money suit then proceeded ex parte since the respondent number 2 and 3 failed to file the written statement. The Court of the Assistant to Deputy Commissioner Shillong by judgment dated 19/8/2011 decreed the suit in favor of the respondent number 1, holding that the respondent number was entitled to a sum of rupees 1 crore 50 lakh 73,101 rupees from the respondent number 1, along with interest at the rate of 12% per annum with effect from 1998 till 2009, and also at interest at the same rate from the date of institution of suit till the date of decree and thereafter till realization of the decree till amount. Pursuant to the above, a decree dated 19/8/2011 was drawn. So, my lord, ultimately the civil court did not allow 8 crore 88 lakh rupees, my lord. They allowed only the entire amount of 1 crore 50 lakh rupees, my lord. Thereafter, my lord, the state respondent then preferred an appeal against the judgment and decree dated 19/8/11 before the learned additional deputy commissioner. The learned additional deputy commissioner, Shillong, then wide order dated 19/12/14 was pleased to dismiss the said appeal, thereby upholding the judgment and decree dated so and so, passed in money suit number so and so. State respondents agreed by the same, then preferred a review petition against the judgment and order dated so and so before the learned additional deputy commissioner. The learned additional deputy commissioner, by order dated 15/6/15, was pleased to dismiss the review petition. That sometime in the year 2014, the respondent number 1 filed a money execution case number 13T of 2014. But this is where the problem starts, my lord.
Execution case.
My lord, 13T of 2014 before the Assistant to Deputy Commissioner Shillong for execution of the decree dated 19/8/11 passed in money suit number so and so. In the course of the proceeding of the said execution case, when the state respondent filed an application before the execution court for stay of the execution proceeding, the learned execution court then, by order dated 3/12/15, directed the state respondent to deposit 50% of the decretal amount by way of bank guarantee. Pursuant to the above, the judgment daters submitted BG number so and so, issued by Meghalaya Rural Bank for a sum of rupees 5 crore 27 lakh 90,248 rupees. Thereafter, the learned court, by order dated so and so, directed Meghalaya Rural Bank to transfer the said amount of rupees 5 crore 27 lakh to the account of the respondent number 1. Pursuant to the above, Meghalaya Rural Bank transferred the said amount.
How was this 5 crores determined?
My lord, this was determined on the basis of, they say, my lord, I'll take your lordship to the decree. That is where the problem is, my lord.
So the original degree was for
1 crore 15 lakh. 1 crore 15
plus
lakh rupees.
interest.
Plus interest, my lord.
So it came to 5 lakh.
It cannot,
5
my lord.
crores.
That is why I wanted to point out, my lord, even if you calculate at any rate of interest, my lord, even if it is 100% interest also, then also it will not amount to that much, my lord. But interest awarded was only 12% per annum. So if you calculate by any way of calculation, my lord, the amount will not reach that, my lord. But what the executing court did, my lord, they came to figure that this will be the 50% amount, 5 crore 27 lakh rupees, asked the state government to give a bank guarantee. The state government, having no choice, my lord, they submitted a bank guarantee. Then execution court directed the rural bank to transfer that 5 crore 27 lakh rupees to the account of the respondent number 1, my lord. And that was done, my lord. Thereafter, my lord,
yes,
the learned execution court, by order dated 6/4/16, passed in money execution, observed and directed as follows. The bailiff is directed to submit a report with regard to the same of the holder of bank account of HDFC Bank, which the said amount of rupees 14 crore was transferred by Meghalaya Rural Bank as per the statement of accounts submitted by Meghalaya Rural Bank and forwarded by the bailiff. Let notice be issued to the HDFC Bank, directing the bank not to release any amount from the said account as mentioned in the statement of account attached with the bailiff's report till further orders of this court.
yes.
Now, my lord, 14 crore rupees that was there in the HDFC Bank, my lord, that was directed to be frozen, my lord, by the execution court. Now what happens, my lord, para J, that in the meantime, while the money execution case number was pending, sometime in the month of February 2016, the state respondents filed a second appeal being RSA number before this honorable court against the judgment and order dated 19/12/14 passed by the additional deputy commissioner in FAO number so and so, and judgment and order dated passed by the so and so in money suit number so and so. The said RSA number 5/16 was disposed of by this honorable court by the order dated 24/16 with the following directions. Considering the facts and circumstances of the case and the submission advanced by the learned counsel at bar, the matter is hereby remanded to the learned trial court concerned to look into the matter afresh in respect of the bill mentioned above. In the meantime, if the appellant desire, they can file an application before the trial court to explain the situation as to why they could not file the written statement in time and court to consider the same. It is also further mentioned that I am not going to set aside the entire judgment dated 19/8/11 as the dispute between the parties regarding the double billing mentioned above only Let the learned trial court confine to decide the matter regarding double billing until and unless it is required to examine the other issues further. The learned trial court below is directed to dispose of the matter expeditiously, probably within a period of 3 months from the date of receipt of a certified copy of this order. Registry is directed so and so. In the meantime, if there is any execution proceeding pertaining to the disputed amount, shall remain stayed till disposal of this case by the learned trial court below. Then what happens, my lord? This order was passed by this honorable court on 20th April 2016, my lord. Now, and this honorable court directed to decide the matter within 3 months' time, my lord. Now your lordship will see what happens thereafter, my lord. This honorable court, by order dated 24/16, was pleased to remand back the matter to the learned trial court to look into the aspect of double billing and also other issues, and also allow the state respondents to file an application before the trial court to explain the situation as to why they could not file the written statement in time, and court to consider the same and has further stayed the execution proceedings till disposal of the case suit. And this honorable court had granted 3 months' time to do the same. However, the learned trial court, showing unusual haste in the matter and misinterpreting the whole purport of the order passed by this honorable court, called up the case record of money execution case number on 22/4/16 itself, my lord, just after 2 days, and passed the following order. CR put up on call, learned counsel for decree holder is present and file petition number so and so. He states that after hearing both the parties, the Honorable High Court has passed the order dated so and so, which has also been annexed along with the petition. Learned counsel is prayed for being allowed to place the new consented decree on record as per the order dated 24/16 passed by the Honorable High Court in so and so, and also prayed that the portion of the decree amount deposited in the account of DH at Vijaya Bank bearing number so and so as the bank guarantee may be adjusted and released to the decree holder to proceed further with the recovery of the rest of the amount. Learned counsel for the judgment debtor Srimati J. Marak is also present and has agreed to bring the new consented decree on record the next date fixed for appearance of the parties. Seen and peruse the photo certified copy of the order dated 24/16 passed by the Honorable High Court. As directed by the Honorable High Court, the execution proceeding pertaining to the disputed amount is hereby stayed till disposal of the case by the trial court. The prayer of the learned counsel for the DH to adjust and release the bank guarantee deposited in the account of DH is hereby allowed. DH to take necessary steps, BA to prepare new decree and place it on record. My lord, kindly see what was the direction of this honorable court, my lord, on 20th April, my lord, and kindly see the hurry, my lord, on 22/4/16, totally against the direction of this honorable court, my lord. What the trial court does, transfers the money, my lord, that 5 crore rupees, my lord, asks for a consented decree. My lord, if there was going to be a consented decree, that should have been recorded in the High Court's order, my lord. Nothing is recorded, my lord. And amount, my lord, kindly see, is more than 10 crore rupees, a public fund, government money, my lord. Now, my lord, I'll take your lordship to the next page, my lord. The learned trial court then prepared a revised modified decree excluding the disputed amount on account of double billing and confirming the rest of the amount on the purported ground that the state respondents have consented to the rest of the amount and that the state respondents have not disputed the rest of the amount. The aforesaid observation finding of the learned court and preparation of a revised modified decree was absolutely illegal and in gross violation of the order dated 24/16 passed by this honorable court in RSA number so and so, whereby this honorable court was pleased to direct the learned trial court, amongst others, to look into the aspect of double billing, to look into the other issues, allow the state respondents to file an application before the trial court to explain the situation as to why they could not file the written statement in time and court to consider the same, and has it stayed the execution proceeding till disposal of the same, till disposal of the suit, my lord. But the learned trial court, in spite of that, my lord, proceeded with the execution, and as I indicated, my lord, in the previous order. However, the learned trial court, acting with material irregularity, had drawn up a revised modified decree while the suit was still not disposed of, and the trial court was still to look into the aspect of double billing, look into the other issues, allow the state respondent to file an application to explain the situation as to why they could not file the written statement in time, and court was still to consider the same. The learned trial court showed undue haste and expediency in the matter and fixed short dates and proceeded ex parte without issuing any further notice to the state respondent, knowing fully well that the matter involves a huge sum of public money and the ultimate sufferer in the matter will be public exchequer. I'll take your lordship to the order sheet, my lord, how the matter were fixed in such short dates, my lord. The learned execution court thereafter, without appreciating the fact that this Honorable Court by order dated 24/16 passed in RSA number so and so has directed the learned trial court in session of money suit number so and so to look into the aspect of double billing and also other issues, and also allow the state respondents to file an application before the trial court to explain the situation as to why they could not file the written statement in time, and court to consider the same, and has also state execution proceedings till disposal of the same case suit. Showing unusual haste in the matter, issued notice dated 28/4/16, just after 6 days, my lord, passes another order, my lord, to the branch manager HDFC Bank Rinja branch, stating as follows: notice, take notice that as per the letter dated so and so, an amount of rupees 14 crore is lying in the bank account of the judgment debtor, being account number so and so, under the name of the Secretary, State Sports Council. My lord, kindly appreciate, my lord, who was the actual judgment debtor, my lord? State government, my lord. State Sports and Youth Welfare Department. This is our bank account, my lord. This account with the HDFC Bank, my lord, where the 14 crore rupees is lying. Now, State Sports Council is an altogether different entity, my lord. But still, what the trial court did, my lord, I'll just read this order, my lord. Take notice that as per the letter dated so and so, an amount of rupees 14 crore is lying in the bank account of the judgment debtor, being account number so and so, under the name of the Secretary, State Sports Council of Meghalaya, with your branch. As such, out of the aforesaid amount, you are hereby directed to deduct the accordingly transfer a sum of rupees 4 crore 96 lakh rupees so and so to the bank account of the decree holder, being account number so and so, Vijaya Bank, Gadikhana, given under my hand and seal. So court directs, my lord, the manager of the HDFC Bank, my lord, to transfer that much amount to the amount of decree holder, my lord. Then I have stated, my lord, that the petitioner states that the aforesaid amount, i.e. account number so and so in HDFC Bank, belongs to the petitioner, State Sports Council Meghalaya, which is a society and which is a distinct entity and which is not a department of the state government. The money lying in the said account belongs to the petitioner and is meant for development of sports activities in the state of Meghalaya. The petitioner, State Sports Council Meghalaya, was not a party either in money suit number so and so or in money execution case number so and so. The learned assistant to DC was also aware about the fact that the account belongs to the State Sports Council Meghalaya and has specifically recorded in the order that an amount of rupees so and so is lying in the bank account under the name of the Secretary, State Sports Council of Meghalaya. However, in spite of the above, directed the branch manager HDFC Bank to deduct and transfer a portion of the decreed sum amounting to almost 5 crore rupees, my lord, to the bank account of Srimati Deoris Marmanian in Vijaya Bank. That pursuant to the above, the branch manager HDFC Bank Rinja deducted the said amount of rupees 4 crore 96 lakh rupees from the bank account of the petitioner and transferred the said amount to the bank account of Srimati Deoris Marmanian. Para P, my lord. Thereafter, the learned execution court, by order dated so and so, passed in money so and so, observed that the remaining amount of rupees has already been transferred to the bank account of DH, and considering the above, the money execution case stands disposed of. So, my lord, the expediency, my lord, this honorable court passed order on 20th April. On 22nd April, one order is passed, my lord. On 28th April, another order is passed, my lord, to transfer the money. And on 2nd of May, my lord, the honorable court disposes of the execution case, my lord, as if the directions of this honorable court are not binding or have no meaning for the execution court, my lord. My lord, in fact, this requires a larger scrutiny by this honorable court, my lord, whether an assistant to deputy commissioner can do like this, my lord. Thereafter, my lord, para Q, my lord. Thereafter, money suit number so and so, on being remanded back by this honorable court by the order dated 24/16 passed in RSA number so and so, was taken up by the learned court of Srimati R.M. Kharsentiu, assistant to DC, on 28/4/16 and was refixed on 25/16. On the said date, none appeared for the state respondent, defendants in the suit, and the learned trial court by the order dated so and so closed filing of written statement by the state respondent. Thereafter, the suit was fixed on several dates and the suit proceeded ex parte, and the learned trial court pronounced ex parte judgment on 27/7/16 in favor of the respondent number 1 for recovery of rupees 21,98,930 rupees along with interest at the rate of 12%. My lord, execution has been completed. Kindly see the situation, my lord. Suit is decided now, my lord. Lordship has noted this, my lord. Suit is disposed of on 27/7/16, my lord. An execution case is closed on, my lord, 2 May, 2nd May 2016, my lord.
What have see against such apparent illegality or irregularity,
My lord.
have you referred any application before a superior court?
But that is why we came before this honorable court, my lord, by way of 227, my lord, bringing in the entire thing to the notice of this honorable court. And this honorable court was pleased to stay, my lord. That there are stay orders, my lord. I'll point out that also, my lord.
This petition was filed in the year 2016. Yes.
16, my lord, that point of time. My lord, this honorable court by the stay order has reverted back the subsequent 4 crore 96 lakh rupees to the HDFC Bank of our State Bank, my lord, and frozen that amount.
No, that is incorrect, my lord.
I'll point out because
the account is the amount is lying in Vijaya Bank, not in HDFC Bank.
Vijaya Bank, it has been frozen. She will not allowed to withdraw that amount, my lord. So that amount has been protected, my lord, by this honorable court. Now, my lord, para 4, page 14, my lord. I'll just continue to read, my lord. That as stated above, the petitioner State Sports Council of Meghalaya was not a party either in money suit number so and so or in money execution case number so and so. The petitioner society is an independent entity. The petitioner has bank account number so and so in HDFC Bank Rinja branch Shillong and has its funds meant for development of sports activities in the entire state of Meghalaya. However, the aforesaid amount of rupees 4 crore 96 lakh has been illegally deducted from the account of the petitioner and transferred to the account of the respondent number 1 in purported execution of a decree with which the petitioner has nothing to do. As stated above, the petitioner State Sports Council of Meghalaya was not a party either in money suit number or in money execution.
So this 4 crore 96 lakhs was frozen.
My lord, our case, my lord, the state has also come before lordship, my lord, by way of 21, my lord, by 28. Our case is, my lord, the 4 crore 96 lakh rupees that has been directed to be executed from our account, my lord, that money should be reverted to us. It is not a state's,
whatever the case may be.
my lord. So our case, my lord, as far as State Sports Council is concerned, is limited. Our relief is limited to that one.
Only it is.
State is against the decree, my lord, subsequent decree and all the other things, my lord.
Yes, please.
So para 4 I was reading, my lord. Second sentence, the petitioner society is an independent society. The petitioner has a bank account number so and so in HDFC Bank Rinja branch Shillong and has its funds meant for development of sports activities. However, the aforesaid amount of 4 crore 96 lakh has been illegally deducted from the account of the petitioner and transferred to the account of respondent number 1 in purported execution of decree with which the petitioner has nothing to do. As stated above, the petitioner State Sports Council was not a party either in money suit number so and so or in money execution case number so, and in no way concerned with the dispute between the respondent number 1 and respondent number 2 and 3. It may also be stated here that the dispute between the parties and the respondent number 2 and 3 pertain to the period prior to the year 2000, whereas the petitioner society was established and registered only in the year 2005. So this is also a very crucial aspect, my lord. Now next para, my lord, that the petitioner states that after deduction of the huge amount of rupees so and so from its account, the petitioner as on 1/8/16 is left only with a bank balance of rupees 18 lakh and is in dire financial state. As such, for the ends of justice, it is necessary that apart from the other reliefs as prayed for, this honorable court may be pleased to direct the respondent number 1 to redeposit the amount of so and so in the bank account of the petitioner. Account number so in the name of the Secretary, State Sports Council with HDFC Bank Rinja branch. And then we have stated the grounds, my lord. So, my lord, as far as maintainability of the present, because they went to Supreme Court, my lord, and Honorable Supreme Court is directed to decide whether 227 is maintainable or not in the facts and circumstances of the case, my lord. Now, my lord, in my humble submission, why I took a lordship to the facts of the case, my lord, the apparent illegality committed by the trial court, my lord. And kindly see the sequence of dates, my lord. This honorable court says within 3 months you decide. Trial court, the second day, my lord, passes an order. Then on 28th April passes another order.
Where's the illegality in that?
But there's absolutely, because our written statement has not been.
If due procedure has been followed.
My lord, as I pointed out, my lord, what this honorable court directed, my lord, in second appeal, will be allowed to file written statement.
No, of course. Like I said, see, if those procedure has not been followed, then of course you can question the manner in which the matter was proceeded.
Exactly, my lord.
But if everything has been, it was in order.
My lord, in my humble submission, my lord, nothing,
you see-
nothing was in order, my lord, because big money is involved, my lord.
Anyway, that's beside the point. The only thing is, you cannot come before this court and say that because this court has given 3 months time, therefore the matter was disposed of in 2 days time. So that is.
My lord, when the execution proceedings have been stayed by this honorable court, my lord. I'm not on that. They can dispose of within 2 days, my lord. When the execution proceedings have been stayed by this honorable court, my lord.
So we are on another aspect of the matter.
My lord.
Yes, please.
Lordship, I'll take your lordship to that order, my lord, because that order will throw some more light, my lord. Page 128, my lord.
Yes.
My lord, what is more interesting is, my lord, the court who was trying the suit, my lord, after being remanded back, and the court executing was the same court, my lord. So court was very much aware about the orders passed by this honorable court, my lord. That your lordship will find from page 131 onwards, my lord. At page 135, your lordship will see the court, my lord. Lordship is 135, my lord. And lordship again turns to page 137, my lord. This is the decree passed, my lord. Same court.
Is there any legal bar to such a
My
procedure?
lord,
Such an
my
action?
submission is the court, had it been two different courts, my lord, there can be some overlap, my lord. If trying the suit is a different court and executing court is a different court, my lord, there's a possible that there may be some overlap, my lord. If the information has not reached the court or the facts were not informed to the executing court or to the trial court, but it is same court, my lord. And more importantly, my lord, as I pointed out, execution matter has been closed earlier, my lord, and suit is decreed after 2 months, my lord. My lord, in my humble submission, that is under CPC, that is not possible, my lord.
Of course, that is apparent. That is apparent.
My lord. I don't need any citation for that, my lord. I don't think we can get a citation like this, my lord, that decree has been executed first, my lord, and the decree is passed subsequently, my lord.
Putting the cart before the horse.
My lord. Now, my lord, my lord, second aspect, what is more glaring, my lord, the entire facts. My lord, the decree amount is 21 lakh rupees, 98,000. That your lordship will find at page 161, my lord.
One.
161, my lord. Entire claim. Page 165 also is reiterated, my lord. Page 165, lordship can see.
Yes.
Plaintiff is entitled for recovery of a sum of rupees 21,98,930. Then, my lord, recovery of interest from the dependents on the decretal amount at the rate of 12% per annum from 2000 till 2009. Now, my lord, I pause for a moment, my lord. 9 years and 12% is the rate of interest, my lord. So 12 into 9 is 108. So 108%. So when the decree is 21 lakh rupees, my lord, interest will be another 21 or 22, 23 lakh rupees, my lord. The total amount will come to only 45 lakh rupees, my lord. What has been executed, your lordship will see, is more than 10 crore rupees, my lord. Even we take subsequent interest also, my lord, from 2009 onwards, we are into 2014, my lord, 15 years, my lord, again 12%. 15 into 12 is 180%, my lord. So even we add by any stretch of imagination, my lord, the calculation will not even cross 1 crore rupees, my lord. My lord, your lordships can seek how the calculation is to be done, because I am also not an account person, my lord. This decree, my lord, if it is executed today, how much will be the amount payable?
This decree was only after the suit was finally disposed of.
Finally, total amount decreed is 21 lakh rupees.
This, this is apart from the execution proceeding which has already taken place. You say that execution has already taken place.
Yes, my lord.
Execution proceeding already taken place.
Almost 10 crore rupees something has already taken place, my lord.
Yes. Thereafter, the suit was finally disposed of, heard, whatever.
My lord.
And the subsequent degree was, the decretal amount was
My lord, let me
21.
just clarify on this point, my lord, just because actually there are two parts to this judgment. Now, this court in RSA number so and so, which my friend had pointed out, has said that in respect of the amount of the bills which have been agreed by the parties, that amount should be paid. Now there were disputed bills.
That is the 1 crore 15.
Yes. No, there are two parts. There are two parts, because when the decree was initially passed, the court said that the only disputed bills, which are a number of bills, I think around 30 bills which were disputed.
Double billing.
Yes, double billing. So this court upheld the decree to that extent. For the rest of the disputed bills, they said this court said you go to the trial court. And
Yes, that is with regard to that 1 crore 50 lakh something.
Yes. So there are two parts.
Okay.
My lord, even if we assume that, my lord, it is clear that out of 1 crore 15 lakhs, 50 lakh rupees was already paid to them, my lord. That has come on the High Court's order, my lord. So the amount outstanding there was 65 lakh rupees, my lord, and another 21 lakh rupees, my lord. So total amount becomes 80 lakh rupees, my lord. Now 80 lakh rupees, because law prohibits compound interest, my lord, lords is aware about that. Interest Act clearly says that no court can grant interest on interest, my lord. Even we take decree amount as 80 lakh rupees, my lord, and period is 20 years, my lord. 20 into 12 will be 240%. The total amount will not exceed 2 crore rupees, my lord. Whereas the executing court has already executed 10 crore rupees, my lord. My lord, this is the aspect which state has to satisfy, lordship, my lord.
What I fail to understand is
My
this. If I can understand, I may be, not be able to comprehend what is going on. For the decretal amount of 8 crores or something, that was on account of a proceeding which has gone ex parte.
Yes. My lord.
All proceedings have gone ex parte.
All proceedings before trial court were ex parte, my lord.
Okay. So now we are talking about that ex parte proceeding.
My lord.
Eventually you went to High Court and matter, was seasoned by the High Court, and a direction was given for the matter to be reopened, giving you a chance to file written statement.
My lord.
So it was that proceeding.
My lord. The second degree has been passed on that, my lord.
So the degree which eventually, then the proceeding was allowed, and it traveled before the trial court.
My lord.
And eventually the trial court came to a finding, and a degree of 21 lakh was
on the disputed bills, my lord.
Okay. So what happened to the 8 crores now?
That was
8 crore has already been executed, my lord. Whereas, but that is why we have come.
You see, the whole exercise has become,
No, my lord, the
futile.
5 crore rupees has been frozen by this honorable court, my
5
lord.
crores.
My lord. 5 crore has been, after looking at the illegality,
Out
my
of
lord,
that 8 crores, 5 crores has been frozen.
frozen, my lord.
And 3 crores.
Out of the 8 crores, 4 crores was given to us.
Okay.
On the basis of bank guarantee by the government.
From
So
Meghalaya,
half the amount was already paid to us. Then the other 4 crores is what my friend is talking about. Not the entire amount has been frozen.
So, my lord, my case, my lord, as far as State Sports Council is concerned, my lord, our case is, my lord, that we were not a party to the suit.
Oh, that is.
We are not a party to the execution proceedings. How can our bank account be attached and money be directed to be transferred from our bank account to them, my lord? My lord, their case is, my lord, the same person is the secretary in the State Sports Department, my lord, and he is also the secretary of State Sports Council.
That does matter.
My lord, entities are different, my lord.
Entity, yes, that does matter.
So one person is holding two dual charges, or sometimes they hold 5 charges, my lord. That doesn't mean that.
You see, in a legal proceeding,
My lord.
you cannot import personal
My lord.
knowledge.
And my lord, then their contention is, my lord, to avoid the execution, this money was transferred to State Sports Council's account. To that effect, there is no evidence, my lord. And once it is done, my lord, court does not have power to attach the bank account of a third party, my lord. That is our case, my lord. As far as the amount, how much should be the amount, how much should be the decree, my lord?
As far as this court is concerned,
My lord.
The facts need not be looked into because we are not here on appeal. That's number one. It is only, you see, once you have come under 227 or, by way of revision,
My lord.
it is only the purported irregularity, impropriety, or with or without jurisdiction if the matter has been proceeded with. That is, I think that will be the limited exercise.
So, my lord,
of this court.
as far as 21 is concerned, my lord, our limited case, my lord, is that we were not a party in the money suit or in the execution proceedings or in the second appeal filed before this honorable court or in the first appeal filed before the deputy commissioner, my lord. We are altogether stranger to the entire proceedings, my lord. Our bank account could not have been attached without, and that also by force, my lord. Court is issuing a direction that and asking the bank manager of HDFC Bank to freeze and come to court, my lord. He was asked to come to the court, my lord. And so much of expediency shown by the court, my lord. 20th April is the order passed by this honorable court, my lord. 22nd, one part is frozen. 26th, second part is frozen, my lord. And 2nd May, matter is disposed of, my lord.
It is always, you see, it is always a good sign as far as the High Court is concerned to see that the lower courts are
functioning properly,
pursuing matters expeditiously. How they do that is a different thing.
My lord. But my lord, kindly see the.
Recently, I saw in the newspaper one POXO matter was disposed of in one day.
My lord, that may be good, my lord. But when there are directions from the higher court, my lord.
That's beside the point.
My lord. So, my lord.
So anything else?
My lord. So looking at the irregularities and illegalities, my lord, in the proceedings, my lord, in my humble submission, this is the fittest case for exercise of jurisdiction under 227 by this lordship.
Yes. Any authority?
Subject to what?
Any authority on this subject?
My lord, on 227, my lord, I have a compilation of some of the authorities, my lord.
So, authority as in when you are not a party to the suit, a decree was issued against you.
My lord,
how do you?
My lord, but basically, I have authorities on what are the expanse of powers under 227, my lord.
Oh, that is it.
But I can place that also, my lord. By today itself, I'll place it, my lord. A decree cannot be executed against the third party, my lord.
Exactly. It's apparent, but
you
have to be supported by the law and the authority.
My lord, because the executing court had ample power, my lord. After all, this is a state government, my lord. This is not a private individual who will run away to Bangladesh or Nepal, my lord. This is a state government. If money is not there in the bank account of a state sports department, my lord, whether court is without any authority, without power, my lord, they can call personal appearance, they can send to prison, my lord. There are modes of execution in the CPC, my lord. But court cannot go to that extent that on their submission, my lord, that money has been transferred from, is there in the State Sports Council's account, so you freeze that bank account, my lord. That is absolutely illegal, my lord.
See, if you feel that any illegality or any impropriety has been done to you,
My lord.
at that point of time, you could have resisted it. Where is the hurry for you to, as soon as a direction was given that you have to deposit the money in, you issue the bank guarantee?
No, my lord. My bank manager was called to court, my lord. Our bank account in HDFC Bank, Rinja, my lord.
Bank manager would function under your instruction.
No, my lord. When court's direction is there, he has to function under the court direction, my lord. I'll point out that order, my lord. What the court
Yes,
directed.
I got your point.
My lord.
Got your point.
Without even asking, without even informing State Sports Council, my lord, court directs HDFC Bank manager to deduct that amount from our bank account, my lord, and transfer it to Vijaya Bank, and that was already done, my lord.
You initiate a separate proceeding for him to compensate whatever has been lost by you.
My lord, the amount has been protected by this honorable court, my lord.
Okay.
So money is still there in their account. That money should be refunded to us, my lord. Now execution, if they want to execute, if they are entitled to execution, my lord, they have execution court has ample remedy, my lord. They can send to prison, my lord, the officials of the department if they don't pay, my lord.
The legal aspect, this court will look into.
My lord. So, my lord, on that aspect, I'll place the citations, my lord. By today, it should be placed.
Yes.
May it please, Lordship. Lordship, although I had observed that the petitioner here, the State Sports Council, the secretary, is the same person as the Director of Sports who has been made respondent number 3 in this instant petition.
Yes.
Although he stands in a different footing, as your Lordship observed, one as the Secretary State Sports Council and one as the Director State Sports Council. Now, the last leg of argument of my learned friend is that no, it's by way of the court's order that we were made to pay that amount of 4 crores. My Lordship will keep in mind that this is the same person. He's acting at one hand as a secretary, one hand is director. So he cannot claim ignorance. Lordship has to keep that in mind. In this particular revision petition, although my friend has gone into the merits of the case, they said we are not interested in what transpired in title suit in the execution case. Our only case here is that our money, my money has been deducted, although I'm not a party to the case. Now, from the averments made in the petition, my lord, we'll see that they're very much aware, because he's the same person, acting in 2 different capacities. Now, before coming to the merits, my lord, I would like to dwell first on the maintainability. Now, for the purpose of for the court to decide on the maintainability, my lord will come to section 47 of the secrecy. Firstly,
Section 47.
47. Now, questions to be determined by the court executing a decree.
Yes.
All questions arising between the parties to the suit in which the decree was passed, or their representatives, and relating to execution, discharge, or satisfaction of the decree shall be determined by the court executing the decree and not by a separate suit. Not a separate suit, but not by way of a separate proceeding, one can say. Now, 3, where a question arises as to whether any person is or is not the representative of a party, such question shall be, for the purpose of this section, be determined by the court. Now, for the purpose of this section, a plaintiff whose suit has been dismissed and a defendant against whom a suit has been dismissed are parties to the suit. For the purpose of this section, a purchaser of property at a sale in execution of a decree shall be determined to be a party to the suit in which the decree is passed. And all questions relating to delivery or possession of such property to such purchaser or his representative shall be deemed to be questions relating to the execution, discharge, or satisfaction of the decree within the meaning of this section. I'll come to the case laws later. Now, the Supreme Court, while deciding the issue on 47, has said that even a third party who is aggrieved by an execution should file before the appropriate court, and not by way of a separate proceeding. Now, my lord, will come to important section is 60, section 60. Property liable to attachment and sale and execution of a decree. The following property is liable to attachment and sale and execution of a decree, namely lands, houses or other buildings, goods, money, banknotes, checks, bills of exchange, hundis, promissory notes, government securities, bonds or other securities for money, debts, shares in a corporation, and save, as hereinafter mentioned, all other saleable property, movable or immovable property, belonging to the judgment debtor, or over which, or the profits of which he has a disposing power, which he may exercise for his own benefit, whether the same to be held in the name of the judgment debtor or by any person in trust for him in his behalf, provided this is not important. My lord, will come to Order 21, Order 58.
Order
58.
50.
Order 21.
Order 21 or order?
Order 21, Rule 58. My lord has got it?
Yes.
Rule 58. Adjudication of claim or to or objections to attachment of property.
Yes.
Now 60, my lord, has seen that what are the properties liable for attachment? Even money would come under the definition of property. Now, my lord, where any claim is preferred to or any objection is made to the attachment of any property attached in execution of a decree on the ground that such property is not liable to such attachment, the court shall proceed to adjudicate upon the claim or objection in accordance with the provisions herein contained, provided no such claim or objection shall be entertained where before the claim is preferred or objection is made the property attached has already been sold, or where the court considers that the claim or objection has decidedly or unnecessarily delayed. All questions, including questions relating to right, title or interest in the property attached, arising between the parties to a proceeding or their representatives under this rule and relevant to the adjudication of the claim or objection, shall be determined by the court dealing with the claim or objection and not by a separate suit. So what these sections, section 60 and Order 21, Rule 58 contemplates is that if even a stranger to a suit, as they claim, ought to file an application before the same court, before the executing court. Here they waited, I think, for 4 months before they came to this court. And it is not that the petitioner was not aware. They were very much aware. He's the same person. In fact, that amount, my friend had drawn the attention of this court to when was the amount transferred by the present petitioner to the account of State Sports Council. It's on the date on which he was supposed to report to the court. Now the court has passed an order, the trial court, asking the bailiff to please furnish the accounts of the Director of Sports. So I think it was on 7th April 2016 that the trial court had fixed the date for the report of the bailiff. On that same date, this Director of Sports, who was aware of the earlier order passed by the court, he transferred an amount of 14 crores, there was around 15 crores, to the State Sports Council. Now, my lord will have to see the actions of the petitioner here. And on the same day, he also files a report to the court saying that the director of sports in the account has only a few lakhs. Because why? In the morning of 7/4, he had transferred this amount. And this amount, my lord, now we come to the crux of the matter. As claimed by them, is exclusively for State Sports Council. They have also annexed a copy of the statement. Now, my lord, we'll see whether this account is really the account of the State Sports Council. My lord, to come to this, of course, this is into the merits of the case, but still, my lord, I want to highlight to this court the action of the petitioner. My lord, will come to page 145. Annexure 16.
Yes.
This is the statement of annexed by them. Purportedly, this account belongs to the State Sports Council of Meghalaya.
Yes.
Well, we'll see. I will not take your lordship into too much of details. That this account is being used by the Director of Sports, not only by the State Sports Council. This account, my lord, is being used by the Director of Sports to pay money to other associations, organizations, and in fact, from this account, an amount of on 7/6/16, an amount of rupees 4 crores was transferred to Director of Sports. Now, how did I come to know regarding this issue? Well, to clarify the matter, because when I took over this case, this is public money. It should not be squandered. That's why I sought for the RTI. From the State Sports Council, as well as the Director of Sports. Now, one of the queries raised by the petitioner, by me, respondent rather, in this RTI is whether the State Sports Council, this particular account, is being used by the State Sports Council also for making payments and receiving payments on behalf of the Director of Sports. The answer is yes. The answer is yes. And Lord, another very intriguing factor in this case is when I sought for an RTI, in one of the RTI, is that what is the budget of State Sports Council? The reply is that during the year 2016-17, the budget is around 8 crores. The annual budget of State Sports Council. Oh my Lord, how did the Director of Sports transfer 14 crores? That also in a single day. This is what has happened here. Let us come to my affidavit by the respondent number 1. We have filed an affidavit. Now, these have not been controverted in any manner by the petitioner.
Anyway, you see, this is a revision.
Yes, this is a revision. So, but we had sought for permission to file the.
I don't think affidavit can be filed like that.
Yes.
Now, my lord, there is no bar there's no bar because these are important
Yes,
issues.
there's no bar. There is no bar, no doubt.
Yes.
But there is also no bar to the effect that the same has to be controverted.
Yes, the same has to be controverted because these are.
No, it may be controverted, it may not be.
Yeah.
That is the option of the parties.
But what is the result if they don't controvert this? Whatever I said is true. My lord will come to.
You have a copy of the. Have you?
Don't say.
Very sorry, I think this. Since 2016.
No, this was filed in recently.
Look at the way I've.
My lord, we will replace it.
It has been pasted by salute tape, and in spite of that,
My lord, we will give you another copy.
we cannot restore this. Don't go extra. You can.
My lord, we will give the supply.
Me too. It has shown. Give me a copy.
Photocopy.
Oh, this is 2016. You are referring to this affidavit dated 2/9.
No, 27/6/2023, my lord.
Okay. Oh. (27/6).
2023. Affidavit in opposition on behalf of respondent number 1.
27/6. Yes. This is okay.
My lord will just come to. I will not take page 7. Page 7, para 17 onwards. No?
Yes.
That as regards the averments made in para 4 of the petition, the answering respondent say that in order to have a clearer picture of the financial aspects and accounts maintained by the petitioner and the director of sports, respondent number 3, he had sought for information under the RTA Act 2005 from both the entities. The director of sports through its PIO by letter dated so-and-so has answered 5 queries raised by the answering respondent and is indeed revealing to note that apart from other anomalies relating to the budget of the petitioner, payments are being made by the respondent number 3, director of sports, through the account of the petitioner, which implies that there is no difference in monies received or paid from either of the entities. To buttress this fact, the answering respondent craves leave of this honorable court to cite examples of the irregularities, if not illegalities, being perpetrated by the State Sports Council and the Director of Sports as follows. The annual budget of the State Sports Council, routed through the Director of Sports for the year 2016-17, non-plan is 39 lakhs 50,000, plan is 750 lakhs, and the total is 7 lakhs 89,000. 7 crores 89 lakhs 50,000. Question is, how did the Director of Sports Youth Affairs transfer the 15 crores on 4/4/2016 to the State Sports Council? Now, in answer to query number 2, whether any payment has been made by the Director of Sports through the accounts of State Sports Council in the year 2014-18, the answer is yes, as per details provided in Annexure 2. This indicates that the Director of Sport utilizes the funds of the State Sports Council to make payments on behalf of the Director of Sports. As per the details provided by the PIO Sports and Youth Affairs at Annexure 2, for the year 2014-15, a total amount of 12 crores 77 lakhs 60,000 was transferred to State Sports Council, whereas as per the annual budget for the year 2014-15, the State Sports Council has been earmarked 8 crores 27 lakhs 90,000. Similarly, for the year 2015-16, amount of funds released to State Sports Council was 32 crores, 86 lakhs 95,714, whereas the annual budget of the council is 7 crores 89 lakhs 50,000. As per Annexure 2, there is no indication that...
So, according to you, this ought not to be?
Yes. So this is what is happening between the State Sports Council and the Director of Sports. This. And here they come and say, we have no money.
To escape liability?
Yes. Merely to escape the liability. My Lord will see, as per Annexure 2, there is no indication that on 4/4/2016, this is the date on which the 15 crores was transferred, any amount was transferred from the Directorate of Sports to the State Sports Council, which is contrary to the statement of accounts dated 4/4/2016, furnished by the Director of Sports to the Executing Court. All the above facts indicate that the accounts of the Director of Sports and the State Sports Council are utilized interchangeably and in a haphazard manner. So, my Lord, what is happening here? They have come before this court portraying that we are a separate entity. This account belongs to us. It's got nothing to do with the Director of Sport. Falls flat on the face of the records. That amount was transferred just to avoid liability, and there was no illegality done by the trial court. In fact, the trial court has done it correctly. When she realized that this fellow is playing with the court issued an order that amount should be transferred to me. It is not a question of a stranger to a suit. I had nothing to do with the suit. And the court has executed the decree taking that money. That is not the case, my Lord. Now, E, my Lord, that in reply to query number 4, which is whether the Director of Sports and Youth Affairs has received any funds, money, transfer from the accounts of the State Sports Council in the year from the year 2014 to 2018, the answer is the negative, whereas the records would indicate otherwise. Annexure 16, my Lord, which I pointed out to the petition. My Lord, in the statement of accounts which I pointed out, on that day, on a particular date, 4 crores was transferred from State Sports Council to the Director of Sports. Yet here they say no. State Sports Council has no business to give us any money. The records, their document speaks otherwise. In reply to query number 5, the PIO Sports and Youth Affairs Meghalaya has stated that all funds grants to various associations in the state is paid through the office of the Director of Sports and Youth Affairs. The records, however, indicate that such payments had been made through the accounts of the State Sports Council, meaning thereby that the contention of the petitioner that the State Sports Council is an independent entity, especially in matters relating to management of funds, holds no water. So your Lordship will see the statement again. Here, all the associations are being paid from this account, State Sports Council account. Now, my Lord, another interesting, yesterday I had the PIO of the State Sports Council had also given us the lists of cash, bank book and accounts of the State Sports Council for the year 2016-17, that is the period. My Lord, this particular account does not figure in that list. I've stated in my additional. this particular account which they have annexed statement, it does not figure. So it would appear that this account was opened by the then Director of Sports, who is the petitioner in my friend's other revision petition, has opened this account. I don't know on what basis. They ought to explain that, but they have not, and they have not denied. My lord, in the...
So it is not an account of the State Sports Council?
Yes, because they have given us a copy of all the accounts of the State Sports Council.
My lord, I do not know what kind of evidence at this stage, my lord. My lord, kindly turn to page 145, my lord. This is the bank statement from HDFC Bank in the name of Meghalaya State Sports Council. To
But
deny, my lord,
why are they denying?
my lord, these subsequent evidences drawn by them, my lord. The matter can be sent to the trial court, my lord, for examining of all this evidence. Then
That's exactly, my lord. What I said. If they have any grievance as against the execution, they should file before the trial court, before the executing court, not come by way of 227 and make false statements that this is our account, that this account is used exclusively for State Sports Council.
But they should have they denied anywhere that this is not our bank account, my lord. Where is the affidavit? There is nothing in the affidavit, my lord.
My lord will come to the
And whether the lordship will take evidence at the stage of 227, my lord.
It's not a question of, taking evidence. It's just a question of appreciating the facts and circumstances of the case. It is not that this court will take all every contention of the party into reckoning. There will be a different. Yes.
Sorry to interject, my lord. The LC record, the lower court record will be necessary. Why I am saying, my lord, because an objection was filed. I was the counsel then, my lord. What had happened, my lord, if I remember, of course, many years have gone by, my lord. My lord, after the disposal of the second appeal, my lord, subsequently they went ahead with the execution. My lord, no notice was given to us. My lord, one appointed, some other lawyer was appointed. Not appointed, my lord. Copy is served on some other lawyer who has no my lord, information about the case. Behind the back, an order is passed, my lord. I am not even aware. Subsequently,
My lord, that is not an issue in this petition. In this petition, that is not an issue.
Because I was for the sports department. My lord, even my respectful submission, before coming to the trial court, before coming to any decision, evidence has should have been required.
I think your submission is misplaced at this point of time.
The issue here before this court now.
You are appearing for the Sports Council?
No.
I'm for the sports department.
The Director of Sports.
Director of Sports.
For the state.
He is the person who has caused all this. Who has done all this.
Who has made the submission? Your colleague has made the submission?
I have made submissions on behalf of the.
So let's not confuse.
Yes. Let us not confuse this.
Let's not confuse the issue here. Your submission may be relevant.
In fact, my lord, I had also pressed for the LC records because I was informed that subsequent to the order passing the second appeal, a petition was filed. A petition was filed before the court questioning certain aspects of the matter, including the correctness of the decree.
Who has filed a petition? Who has filed a petition?
It was filed by the state, my lord.
State.
By the
Your Lordship, to cut short the issue, my Lord, is on the maintainability. My Lordship will first decide whether these two petitions are maintainable or not, in view of the provisions of the CPC.
Your point is when there's an alternative remedy.
Yes.
So the parties should have gone before that.
Before the executing court, because this is not the right court to raise all these issues. In fact, I have brought to the notice of this court these issues simply because they have taken the stand that this account belongs to State Sports Council, exclusively used for State Sports Council, which is not the case.
But in any case, if matter under consideration is of importance,
yes,
you know very well, even filing an application before a wrong forum can be condoned.
Yes, that is true.
So this court can direct the parties to go to the proper forum.
Yes,
without.
May I answer?
Prejudice
I'll
to their
reply
rights.
to that, my lord. I'll reply to the submissions of.
No, I'm just observing as the submission is proceeding.
I'll reply to that and satisfactorily.
That you will reply, no doubt. Please continue.
Yes. I will come to my My additional affidavit, my lord, we have also filed an additional affidavit to bring on record information which is received later on from the PIO, from the Director of Sports.
But again, Mr. Dingdo,
Yes.
you see,
No, what
affidavits are supposed to be filed only on issues of facts.
These are issues of facts, my lord, because
What is
because the fact is that they have pleaded.
why would facts be considered in a proceeding of this kind?
True, my lord. True. The fact here is that we have brought on record the grants and aid and the ledger account of State Sports Council for the year 2016-17, and this account does not figure. My lord, will see page 9.
9
of my additional affidavit.
Dated the same. This
Additional affidavit. My lord.
Where's the additional affidavit dated?
9/8/2023. Page 8, page 9.
Page 8 and page 9. These are your RTI queries.
Yes. My lord, one query was that does the State Sports Council bestow or provide any grants to the sports clubs and the associations? If yes, under what head or budgetary and the details thereof from the year? No. The answer to query here from the State Sports Council is no. We do not make any grants or aids. But your lordship will see the statement annexed by them. Most of the grants, most of the aids is made to the associations of the state. Now, whether the State Sports Council receives any money, grants from the government directly to its account, that is yes, my lord. Whether the State Sports Council has transferred any money to the Director of Sports and Youth Affairs, Government of Meghalaya in the year 2015 to 17, they say no. Whereas their account states otherwise. 4 crores was transferred to them on a single day. Whether the Chief Engineer of the State Sports Council is a person who maintains the accounts of the council, including the cash book, bill register, information available on payment of ₹2 only per page. That we are not. Now, number 8, my lord. In the year 2016, how much money was received from the State Sports Council, from the Director of Sports and Youth Affairs, and for what purpose? Kindly provide the details. Now, here, my lord, they state that only 7 crores 54 lakhs 1,192 was received. Where's that 15 crores, my lord? In the year 2016, how much money was transferred from the account of the State Sports Council to the Director of Sports? Here also they does not arise. And my lord will come to page 9. Grant and aids for the year 2016, and this is the ledger account. The bank statement annexed to this petition does not figure in this ledger account. It does not figure in this.
Where is the account number?
The account number, my lord, is according to their statement is HDFC Rinja bank account number 5010013366750.
So at page 9, that account did not figure here.
It does not figure. Other HDFC bank accounts figure. That does not figure. It does not figure also in the bank statement which they have supplied to us.
That page 16.
Yes. My lord, I would not, because it's a very big. Now, your lordship, these are the bank accounts as per the ledger which has been reflected for the year 2016-17. My lord will come to page.
This does not correspond with the.
My lord will just come to page 4. I beg your pardon. Page 4 on my additional affidavit. Page 4. My lord, sub-para 2.
Yes.
The deponent on payment of the receipt fee has received copies of the cash book, ledger account, etc., which are very voluminous. The surprising fact is that HDFC bank account number 5010013366750 Rinja branch finds no mention. Another astonishing feature is a copy of the ledger account in respect of grant and aids from so and so to so and so. It transpires 44 crores 93 lakhs was received by the State Sports Council from the Director of Sports. They have not refuted all this. And now they come before this court annexing a copy of the statement on of an account which appears to be non-existent.
And from which account that
amount
was
transferred.
Was said to be.
And now they come to court and allege malafide and against the.
I'll answer that one.
Yes.
Should I answer now?
No, I'm not finished. Now, my lord,
Why are you in such a hurry?
I'll place my decisions, my lord. So, my lord, the entire exercise, they have come before this court making accusations against the trial court has done this, done that. What about them? That is why the factum that this person, the Secretary of the State Sports Council and the Director of Sports is one and the same person, this could have happened only because of that. He knew, although they say as a Secretary of the State Sports Council is a stranger to the suit, but as a Director of Sports, he was directly involved. Look, you've given the list of books, but may not be compilation.
Where's your compilation?
The latest decision in respect of execution of decree is this case of Rahul Shah. Lord, we'll just come to page, internal page 423.
Para?
423, para 1 itself. The present appeals arise out of a common judgment, an order dated 16/1/2020 of the Kerala High Court, which dismissed several writ petitions. The course of the litigation highlights the malaise of constant abuse of procedural provisions, which defeats justice, that is, frivolous attempts by unsuccessful litigants to putting up spurious objections and setting up third parties to object, delay, and obstruct the execution of a decree. That is exactly what has happened here. Now, Lord, it's a lengthy judgment. Now, in this case, my Lord, the Supreme Court has laid certain directions. My Lord, you find that in page 433, internal page 433. para 40, my lord. In so-and-so case, this court had observed that the provisions of the code as regards execution are of superior judicial quality than what is generally available under the other statutes, and the judge, being entrusted exclusively with the administration of justice, is expected to do better. With pragmatic approach and judicial interpretations, the court must not allow the judgment debtor or any person instigated or raising frivolous claims to delay the execution of the decree. For example, in suits relating to money claim, the court may, on the application of the plaintiff or on its own motion using the inherent powers under Section 151 under the circumstances, direct the defendants to provide security before further progress of the suit. The consequence of non-compliance of any of these directions may be found in Order 17, Rule 3. Now, having regard to the background wherein there is urgent need to reduce delays in the execution proceedings, we deem it appropriate to issue few directions to do complete justice. These directions are in exercise of our jurisdiction under 142, read with 141 and Article 144 of the Constitution of India in larger public interest to subserve the process of justice so as to bring to an end unnecessary ordeal of litigation faced by parties awaiting fruits of decree and in larger perspective affecting the fate of the litigants in the process of law. All courts dealing with suits and execution proceedings shall mandatorily follow the below mentioned directions. These are now it will come to 42.11. That's at page 434.
Yes.
Under Section 60 CPC, the term "in the name of the judgment debtor or by any person in trust for him or on his behalf" should be read liberally to incorporate any other person from whom he may have the ability to derive share, profit or property. My submissions is that the petitioner here, the State Sports Council, is a person who has the ability to derive share, profit of the account which was being used both by the State Sports Council as well as the Sports Department.
You see, except for the fact that the same person
Yes.
Is the secretary of the directorate or whatever. Where is the nexus?
The nexus, my lord,
between this Sports Council and the.
That's why I've shown, my lord. The nexus is that this particular account of the State Sports Council is also being used by the Director of Sports.
Director of Sports.
That is where the nexus is. That's why I've gone through the pain of applying for RTI to see whether this account is really being used only for State Sports Council or for the activities of the Director of Sports.
So such a nexus has been reflected in the entries.
Yes, and the answers which have come from them.
Okay.
And the statement of accounts also.
But sometimes they say that the account doesn't exist, my lord. Sometimes
It's
they
there,
don't take one stand, they can't take two stands.
That's why they
But
should
he's saying that the account exists, but you have concealed.
No, my lord, they are saying that this account doesn't exist, my lord. This is what the submission was, my lord.
I didn't say it doesn't exist in there. Then how did they annex a copy of the statement?
They have to choose one stand, my lord. Either account exists or it doesn't exist, my lord. If an account doesn't exist, and we have annexed some false documents with our petition, that was the submission, if I understood correctly, my lord. They said that the bank statement is false because it is not reflected in the RTI reply, my lord.
That is not my submission.
That was submission. We can replay the.
No, what could be understood is this: that the account is there, but in RTI queries and efforts made by the petitioner or the respondent herein to get to the truth, you have concealed the fact that account is also of your department or Sports Council. That is what.
This RTI. What is the question asked by them? What is the reply? We do not know, my lord. But my lord, I only want to draw lots of attention to one page, my lord. Page 144 of the petition, my lord. Kindly see, my lord.
Let me finish.
Yes.
So, my lord, here, as per this decision, section 60 CPC, in the name of a judgment debtor or any person in trust for him. In other words, the Secretary State Sports Council is holding this money in trust for the Director of Sports. Because
Yes,
Supreme Court has said you read it.
I understand your point.
Yes.
The point is, if the decree is directed towards the Director of Sports Council,
Yes.
Director of Sports,
Director of Sports.
but in fact the money is with the Sports Council.
Yes.
So the decree could be satisfied from the account of the Sports Council.
Yes. Especially in view of the fact that this account, as has been shown by me, is being used for making payments in respect of the. They have admitted also.
Yes, it has been used
Yes.
interchangeably.
Interchangeably. Now, my lord, will come to the judgment of Chinmalal versus, this is at B, my lord, flag B.
Should have given an index.
I'm very sorry. We will do that.
This is 1990.
This is 1991 SCC 513.
Para?
Para 10, 11, 12, 13, 14. Now, in this judgment, hello, in para 10, page 517.
Yes.
There is thus a distinction maintained between the decree holder who purchases the property in the execution of his own decree, which is afterwards modified or reversed, and an auction purchaser who is not party to the decree. Where the purchaser is the decree holder, he is bound to restore the property to the judgment debtor by way of restitution, but not a stranger auction purchaser. The latter remains unaffected and does not lose title to the property by subsequent reversal or modification of the decree. The courts have held that he could retain the property since he is a bona fide purchaser. This principle is also based on the premise that he is not bound to inquire into the correctness of the judgment or decree sought to be executed. He is thus distinguished from a nominee party to the litigation. There cannot be any dispute on this proposition, and it is indeed based on a fair and proper classification. The innocent purchaser, whether in a voluntary transfer or judicial sale, by or in execution of a decree or order, would not be penalized. The property bona fide purchaser, ignorant of the litigation, should be protected. The judicial sales, in particular, would not be robbed of all their sanctity. It is a sound rule based on the legal and equitable considerations. But it is difficult to appreciate why such protection should be extended to a purchaser who knows about the pending litigation relating to the decree. If a person ventures to purchase the property being fully aware of the controversy between the decree holder and the judgment debtor, it is difficult to regard him as a bona fide purchaser. The true question in each case, therefore, is whether the stranger auction purchaser had knowledge of the pending litigation about the decree under execution. If the evidence indicates that he had no such knowledge, he would be entitled to retain the property purchased being a bona fide purchaser, and his title to the property remains unaffected by subsequent reversal of the decree. The court by all means should protect his purchase. But if it is shown by evidence that he was aware of the pending appeal against the decree when he purchased the property, it would be inappropriate to term him as a bona fide purchaser. In such a case, the court also cannot assume that he was a bona fide or innocent purchaser or giving him protection against restitution. No assumption could be made contrary to the facts and circumstances of the case, and any such assumption would be wrong and uncalled for. So this is a case, my lord. Here also, what the petitioner is trying to project, I am a stranger, I am not aware. What happened in the suit, what happened in the execution, I am not aware, which is not a fact. In fact, in the entire petition, he stated the history of the case. He knows what is happening.
From records.
From the records, he knows what is happening. On the date that he was supposed to deposit the amount, he instead withdraws the amount from the Director of Sports and transfers it to the State Sports Council. He cannot be called a bona fide purchaser or a bona fide person who had no knowledge of the decree. He had all knowledge. He knew what was happening. And in this judgment, the court said, against such a person, no relief can be granted. If it was a person who was not aware of the proceedings, then yes, protection should be given to him. This next one is C. Asgar and others, versus Mohan Verma and others. This is regarding the maintainability. I'll just read the relevant paragraphs. Are paragraph 40, 40 to 46. Para 42, my lord, internal page 252.
Para 42?
Yes. I'll just read the. And so, this court held that the view taken by the High Court that the only remedy available to a stranger to a decree who claims an independent right, title or interest in the property is to pursue the remedy under Order 21, Rule 29 was unsustainable. The court held that a stranger to a decree is entitled to agitate 42 his or her grievances and claim her adjudication for an independent right, title and interest in the decretal property even after being dispossessed, in accordance with Order 21, Rule 99. Order 21, Rule 97 deals with the stage which is prior to actual delivery of possession, and the grievance of the obstructionist can be adjudicated upon before the actual delivery of possession to the decree holder. In other words, both sets of remedies are available to a stranger to a decree speaking for himself. Now in this case, of course, it was a property. As I've said, Section 60 property means money also. So the only way for a stranger to a suit to have challenged the decree was by filing an application before the executing court itself or by way of an appeal. Not by filing a petition under 227. 46 will come. Para 46.
Yes. Yes.
In view of the settled position in law as it emerges from the above decisions, it is evident that the appellants who were entitled, though they were strangers to the decree, to get their claim to remain in possession of the property independent of the decree, adjudicated in the course of the execution proceedings. The appellants in fact set up such a claim. They sought a declaration of their entitlement to remain in possession in character of the leases. Under Order 21, Rule 27, they were entitled to set up an independent claim even prior to their disposition. Under Order dispossession, under Order 21, Rule 101, all questions have to be adjudicated upon by the court dealing with the application and not by a separate suit. Upon the determination of the questions referred to, And in Rule 101, Order 21, Rule 98 empowers the court to issue necessary orders. Well, my lord, I've also enclosed the judgment of Savitri Devi, which your lordship is very much aware of. It's at D.
Yes.
Of course, this relates to fraud, my lord, and misleading statements made by the petitioner in court. Here's a case where they have made misleading statements, my lord, in as much as the stand of the petitioner is, I'm a stranger to the suit. This account is only for State Sports Council. These are all false statements because the records prove otherwise. It was just a ploy to get away from paying the decretal amount. Now, once he realized that no, this can't be done, he comes jumping before this court under 227. He waits for 4 months. And after this was filed, then as Director of Sports, again he files another revision petition. It's just a cover-up. Nothing less. Then my lord is very, Shalini Shamsetti, my lord is very well aware of. I need not read. My lord has taken this case into consideration in many of your judgments. That's that. But what I want to stress is on the case of Virudhu Nagar. We'll come to para 13. Eleven onwards. Secondly, the High Court ought to have seen that when a remedy of appeal under Section 1041, read with Order 43 Rules so and so, was directly available, respondents 1 and 2 ought to have taken recourse to the same. It is true that availability of a remedy of appeal may not always be a bar for the exercise of supervisory jurisdiction of the High Court. In so and so, this court held that though no hurdle can be put against the exercise of constitutional powers of the High Court, it is a well-recognized principle which has gained judicial recognition that the High Court should direct the party to avail himself of such remedies before he resorts to a constitutional remedy. But courts should always bear in mind a distinction between cases where such alternative remedy is available before civil courts in terms of the provisions of the CPC and cases where such alternative remedy is available under special enactments and or statutory rules, and the fora provided therein happen to be quasi-judicial authorities and tribunals. In respect of cases falling under the first category, which may involve suits and other proceedings before civil courts, the availability of an appellate remedy in terms of the provisions of CPC may have to be construed as a near total bar. Otherwise, there is a danger that someone may challenge in revision under Article 227 even a decree passed in a suit on the same grounds on which respondents 1 and 2 invoke the jurisdiction of the High Court. This is why a 3-member judge of this court, while overruling the decision in Surya Devi, pointed out that orders of civil courts stand on different footing from orders of authorities or tribunals or courts other than judicial civil courts. Therefore, wherever the proceedings are under the CPC and the form is the civil court, the availability of a remedy under CPC will deter the High Court not merely as a measure of self-imposed restriction, but as a matter of discipline and prudence from exercising its jurisdiction of superintendence under the Constitution. Hence, the High Court ought not to have entertained the revision under 227, especially in a case where a specific remedy of appeal is provided under the CPC itself. Another aspect which was overlooked by the High Court was that the second respondent here, namely so-and-so, was already restrained by the subcourt from I'll just give you this settlement also. It's 2022, Volume 4, SCC 181. 2022.
2022 4
Volume 4, SCC 181. Paragraph 15, 16. We have not annexed it. Yeah. We'll supply a copy. Should we stop here for now and continue?
Yes, we can. So we'll continue in the second half.
Second half.
Two.
Yes. We will supply our
CR 228 2016. My lord has given us the liberty to file the written submissions.
But that is only in respect of maintainability.
I think that
This one is only on maintainability only.
Yes, the same. I know, same. But since there are two cases, so argument have been advanced accordingly.
We have concluded it's only for the purpose of filing a written
submissions.
So have you done it?
Well, once this is concluded, I'll file it back.
I'll file it by today.
I'll file it the day of, once I receive a copy of the written submission filed by your Learned Senior, I'll file it in 2 days' time.
Two.
Much good.
I think we'll not be able to do it today. I've got a meeting in the afternoon.
We'll continue tomorrow then.
Should we continue? Yes, no? I'm very sorry. I was about to leave. I forgot that I have a meeting in the afternoon.
Tomorrow day after? Tomorrow is Friday.
We'll continue Monday then.
Monday? Shortly. Monday,
Tuesday.
Monday and Tuesday DB, lots of matters affect.
No, Monday DB, I don't think will be. No,
Monday, Chief Justice sits in single bench also. Monday and Tuesday matters are there.
Wednesday
I think will be better.
Wednesday will do.
Wednesday is
13th.
13th also matters. 11th or 14th.
In the meantime, we'll prepare our written submissions also.
I think 14th will be better, my lord, instead of 13th. Because 13th also some matters affect before single bench of.
14, I don't think I'll be able to sit for long because again 14 we are leaving.
So 13, my lord.
13.
We'll try.
13. heard submission of the parties in part. Hearing will continue in the next date fix as agreed to by the parties. This is matter on 13th.
13.
For further hearing. 13.
Okay.